is Mindy Beaton. I'm the chair of the Political Science Department, and on behalf of the Department of Political Science at John Carroll University, I want to welcome you to our annual Suopis lecture. The Suopis lecture series is an annual public lecture sponsored by the JCU Political Science Department in memory of Donald William Suopis, class of 1970. It's for the purpose of hosting a keynote speaker whose area of expertise, academic study, and/or professional pursuit centers on those issues that were of special interest to Donald W. Suopis, including contributions of citizen activism and public service to effective democratic governance. Donald's unflagging commitment to serving the public good through his work in government service and volunteerism has set the parameter for lecture topics and critical debate. The general purpose of the lecture series is to educate John Carroll University students, staff, faculty, and members of the larger Cleveland community on the relationship between participation in the political process, both as private citizen and public official, and serving the public good, and a public official, and serving the public good. All right, so it's my pleasure to introduce Bevlynn Sledge. Bevlynn Sledge is a graduate of John Carroll University's class of 2009 and Cornell Law School's class of 2012. She is currently a writ attorney at the Northern District of Ohio Federal Public Defender's Office, where she works in the Capital Habeas Unit exclusively representing death sentence prisoners. Her topic is of particular interest to many of us at this university, and we're really honored to have you here. Thank you so much.
Thank you. All right, can you hear me okay?
Yeah. Yes.
All right, so thank you for having me. Before we get started, I'll say a little bit about myself. As she said, I'm a 2009 graduate of John Carroll, and then I went on to Cornell Law School. Both John Carroll and Cornell place a strong emphasis on community service and giving back. And during my time here at John Carroll, I did volunteer work, and during my time at Cornell, I did public interest law and government law. I've always wanted to help the little guy, and that's because I consider myself to be one of those little guys, and I think we ought to stick together. So that's me. I'm happy to talk to anyone more specifically about the path that led me to do the work that I do today, if you're curious after the talk. Now, I may do some polling, some simple show of hands questions to keep this somewhat interactive and a little less boring. So please don't leave me hanging. In fact, let's do a practice run right now. Can I have a show of hands if you are in this room? Oh my gosh, that was fantastic. Okay, thank you. Even though I'm going to do some polling, I will ask that you please hold any questions that you have until the end. All right, so we're here today to talk about the machinery of death. I'm going to give a bit of an overview of the machine and how it's supposed to work from a constitutional standpoint versus how it actually works in reality. We won't cover everything in the short amount of time that we have, but we're going to talk about some of the big problems. The title of the talk, The Machinery of Death, comes from a Supreme Court dissent written by Justice Harry Blackmun, who served on the court for 24 years, and whose position on the death penalty actually evolved from a position of carefully reasoned, constitutionally anchored support for the death penalty to equally carefully reasoned and constitutionally anchored dissent. He was not a bleeding heart. It was Justice Blackmun's position that you don't have to believe the death penalty itself is wrong in order to believe that it's unjust. I hope that after we talk about the way the machine works today, you question whether it's just and whether it can ever be just, because that is why we execute people. We execute people to do justice. If we are executing them for any other reason, then we are no better than we think that they are. And the justice that we, as a people, have consented and agreed to abide by as a society is prescribed by our Constitution. So the death penalty has to comport with what the Constitution requires, or the death penalty is unjust. Really quickly, show of hands if you support use of the death penalty. This is not a trick question. Please feel free to be honest. Does anyone in here support the use of the death penalty? Thank you. Anyone else? Sort of? Under any circumstance? Show of hands if you do not support use of the death penalty. Okay, that's surprising. I'm a federal capital habeas attorney, also known as a writ attorney. That means I get a client's case after it's already worked its way entirely through the machine. So I have a bit of a bird's eye view about how the process works. My job is to review the entire case for legal errors of a constitutional magnitude so great that the client's sentence cannot be considered just. When I get the case, my client is often very close to being put to death. And it is simply my job to make sure that the death sentence is constitutional and just. So with that said, let's talk about the machine. No one expects the machine to function perfectly, but there are some basic constitutional standards that are supposed to be met. The most fundamental of those standards stems from the Eighth Amendment prohibition against cruel and unusual punishment. And it's that we are only supposed to use the death penalty to punish the absolute worst criminals for the absolute worst crimes, because it is the ultimate and most absolute punishment, the most irreversible, that should be used against the most irredeemable. In order for a punishment to be considered not cruel and unusual, it has to be proportionate to the crime. If you steal a candy bar and I chop off your hand, that's cruel and unusual within the meaning of the Eighth Amendment because it's way over the top compared to the crime committed. Likewise, in some circumstances, the death penalty is over the top in terms of punishment, even for the crime of murder, and the Constitution recognizes that it would violate the Eighth Amendment if there weren't some rational and consistent way for us to determine which crimes call for the death penalty and which crimes don't. So since the fundamental underpinning for the death penalty's constitutionality, at least in relation to the Eighth Amendment, is that we execute only the worst of the worst, it rests on the assumption that we can in fact separate the worst from the rest. So how in the world do we do that? Aren't all murders terrible? Well, let's do a little exercise with two hypothetical cases. This is going to be a bit graphic and maybe a bit disturbing, but we're here to talk about the death penalty after all. So we're going to take case A, and we'll call it, if it'll pop up, mutilation and decapitation. And we're going to take case B, if it'll pop up. You gonna pop up on me? Doesn't want to. There we go, rage over a woman. Okay. Case A, mutilation and decapitation. Perpetrator lures victim to a remote, wooded area under the guise that they're going on a hunting trip. The victim is a slightly intellectually disabled man. The perpetrator intends to kill the victim rather than take him hunting, and he does so in a very brutal manner. When they get to this remote wooded area, he tells the victim to walk out into the field and to see if he can spot any deer with a flashlight. All the while, he's waiting for the victim to walk into his field of vision so that he can take a shot at him with his shotgun. And he does. And he shoots the victim in the head. And then, when the victim falls in the field, he casually walks over to him and he shoots him in the head again, and again, and again, until the victim has no head. So it's basically decapitation by gunfire. But that's not enough. He wants to make sure he gets away with this, even though it's in a remote area. He wants to make sure the victim can't be identified, so he wants to remove the possibility of fingerprint evidence. he decides to cut off the victim's hands. He cuts off the victim's hands, and then, to get rid of those, he removes the victim's shoes, which happen to be his favorite pair of cowboy boots that he wears everywhere, even apparently to go hunting. He stuffs the hands into the cowboy boots, finds rocks, stuffs those into the cowboy boots with the hands, and tosses the boots into a nearby river where they will hopefully sink and never be found. He then discards the headless, handless body in a nearby pond, hoping that it too will never be found in this remote area, or that if it ever is found, it will be so badly decomposed, it will not be recognized, let alone as human. It is recognized, well, not as human, but the victim thought he was going hunting. So when the body is found, the way that he's identified is that he had his hunting license in his jacket, and it somehow survived being submerged in water, and it had his name on it. And that's how the police figured out his identity and found out who killed him. So that's case A, mutilation and decapitation. Now let's take case B. Case B, perpetrator knocks on an apartment door, gives a fake name so that they'll open the door to him. When the door opens, he immediately sees his rival, shoots his rival in the groin and then in the chest, and then proceeds to beat him up until somebody grabs him and throws him out of the apartment, and then he runs away into the night. His rival, who he attacked for stealing his girlfriend, dies of his wounds. That's the end of the facts of those cases. Does anyone here think that one of these cases is worse than the other? Show of hands. So you would expect that one being worse than the other would be sorted into the worst of the worst category. However, they are both my clients, and they are both on death row. I want to be clear that I'm not saying the client from case A is the worst of the worst or that he deserves to die. I didn't give you all of the facts of that case, and I purposely dramatized it in order to get the reaction that I wanted. But the fact that the point that I'm making is that it illustrates the fact that our current system is not sorting cases in a meaningful way, in a manner that we would expect, and in a way that the Constitution requires. We are not necessarily sorting out the worst of the worst and reserving the death penalty for them. What we will see, and what Justice Blackmun was most troubled by, is the fact that there are way too many opportunities for the death penalty to be employed for reasons other than the severity of the crime or the depravity of the defendant. And it often is. One of those reasons is, let's do this. Do I have to point it at this? Oh, there we go. Oh, go back. Politics and location. So to begin with, the death penalty constitutionally employed must be apolitical. In reality, there are a number of social and political pressures that make it difficult for elected officials both to halt executions and to proceed with them, depending on the political climate they find themselves in. We're seeing that play out on a national scale as well as locally here in Ohio. So here in Ohio right now, we're seeing a difficulty going forward with executions. There's a component to the Eighth Amendment that, in addition to the fact that we are only supposed to be punishing the worst of the worst, the death, when we carry out the death sentence, will not be torturous or involve unnecessary pain or a lingering death. We will respect a defendant's humanity even until the end, even if he did monstrous things, because we are not monsters ourselves. The Supreme Court recently ruled, however, that even if a prisoner can show his death will be torturous, he must also show that there's a less painful alternative that is readily available for the state to use. Otherwise, the state can proceed with the method of execution that is available to it, even though it will cause a severe amount of pain. So what's going on right now is that a federal court ruled that Ohio's current method of execution is the equivalent of drowning a man alive in his own bodily fluids and burning him alive at the same time. However, he could not provide a readily available, demonstrably less painful alternative. So he couldn't meet the legal standard and the state of Ohio can legally go forward and perform this execution. The governor, to his credit, wasn't okay with that. Many believe DeWine felt it would be harmful to his political image to allow such barbaric executions to go forward, even if they were legally permissible. These executions, with this execution method, are nevertheless still being carried out in other states around the country who use the same drug protocol, because it's lethal injection, that Ohio uses. Now, another quick poll. Does anyone here think we should care less about the suffering of these people that we are executing? It is an execution after all. Why do we care how much pain they are feeling? Does anyone feel that way? Does anyone think it's a waste to worry about that? No? Okay. I run into that a lot in the work that I do. When we're making these arguments, when we're going to court, there are protesters. It gets very contentious, and there are people saying, these people did monstrous things. Why do you care how much they suffer before they die? They're being killed for a reason. We care because, once again, these executions are being carried out to do justice. Torture is not justice, it's revenge. The point of a constitutionally secured, state-sanctioned killing is to satisfy the instinctual desire for flat-out revenge, but to do it in an orderly and dignified way so that it can be called justice. Going back to the politics, on a national level, Trump recently announced his desire to use the death penalty against drug dealers, and he also reinstated the federal death penalty, which has sat dormant since 2003. Now, all of a sudden, 5 men are scheduled to be executed by the federal government between December and January, which is an extremely compressed execution schedule. The timing of Trump's announcement and the reinstatement of these executions is no coincidence. Elections are right around the corner, and research shows that the total number of executions performed spikes in election years. So now we have a demonstrable system of executions for votes. So at the end of the day, mountains of studies have been done showing the interaction between fluctuating political climates and the death penalty. There is an undeniably strong correlation, and it clearly violates what the Constitution requires, because the decision of whether or not someone will be executed is supposed to depend on the gravity of the crime and the depravity of the defendant, not who is in office or where they committed the crime. And speaking of who's in office, another significant flaw in the machine is the unfettered charging discretion of prosecutors. Charging decisions are left entirely up to prosecutors, who are often elected officials themselves. They are elected here in Ohio. Just because a case is eligible to be charged as a death case, just because a case qualifies as one of the worst, that does not mean that prosecutors are required to charge that case as a death case. The prosecutor can flip a coin and say, I'll charge this one and I won't charge that one, and there is nothing preventing that from happening. Therefore, the administration of the death penalty is not only influenced by politics at large, it's influenced by personal politics and prejudice, and is very personality driven, depending on the prosecutor whose desk a case lands on. The Supreme Court expects prosecutors to make decisions based entirely on the strength and seriousness of the case. The court has said, defendants will escape the death penalty through prosecutorial charging decisions only because the offense is not sufficiently serious or because the proof is insufficiently strong. So there's no such thing as personal bias, prejudice, or political pressure in a properly functioning constitutional machine. The prosecutor decides to seek death because of the strength of the case and the fact that the defendant is one of the worst of the worst. That is what the Constitution requires, and that is what the court believes, or wants you to believe, goes on That is not reality. A 2016 Harvard study found that compared to the vast majority of prosecutors across America and the vast majority of criminal cases every year, the majority of death cases originate from a tiny handful of prosecutors. The study profiled what it called the top 5 deadliest prosecutors in America. It detailed how whether or not a case is tried as a death penalty case has much more to do with a prosecutor's personal convictions than the crime itself. Taken together, the profiles featured in the study demonstrate that the death penalty has been and continues to be a personality-driven system with no checks whatsoever to ensure that prosecutors aren't abusing their discretion or being swayed by personal prejudice. And on the subject of personal prejudice, there are disturbing race-based correlations to death penalty charging and sentencing decisions. As one example, a North Carolina study found that looking at death cases from 1990 to 2000, found that race was a statistically significant factor in each prosecutorial charging decision. So what the study basically found was, if a black defendant killed a black victim, the prosecutor was much less likely to charge as a death case. So you could escape a death sentence just because you only killed a black person. The system's looking at it as, you only killed a black person. Who cares? If a black defendant killed a white defendant, he was much more likely to be charged as a death case. So racial prejudice is playing a role in who is being charged and sentenced to death, which again is a factor that should have no business entering into the calculus of who is the worst of the worst. So thinking back to case A and case B, the machine fails to sort cases from the outset, despite supposedly being able to and being constitutionally required to. And then prosecutors make arbitrary charging decisions, wholly divorced from the gravity of the case, and sometimes demonstrably influenced by racial prejudice. And then we come to trial itself. Trial is where most of the main gears churn. It's something we're all super familiar with. It's the most important part of our justice system. And that's because justice is what the jury says it is. The right to a jury trial is the only right included in both the original text of the Constitution and the Bill of Rights. And that's because it's the best solution we've come up with. Absent a godlike ability to be omnipresent and know exactly who did what, when, and where, justice is the best educated guess of 12 people who swear an oath to do their best, to hear all of the evidence and all of the testimony and decide what they think happened and who they think is responsible and how that person should be punished. And it's almost never as clear-cut and straightforward as the TV shows would have you believe. I often have cases, and we'll talk about one in a minute, where there are multiple co-defendants, and the question is, who pulled the trigger? Who committed the murder? Who is actually the worst of the worst? And it's not clear-cut, it's a toss-up. So justice is an educated guess. And the machine makes some assumptions about this guess that, if true, are supposed to make it reliable enough to be the basis for putting someone to death. If the machine is functioning as it should, all of the defendant's rights are respected, and the jury is given the opportunity to make its best, most well-educated guess. No information will be withheld, no coerced testimony or confessions will be presented, and a defendant's lawyer will know the law and actually put on a defense. The machine also assumes that juries will be free from external influences and internal biases. For the machine to continue to pass constitutional muster, these assumptions must be valid. they are not. Once upon a time, I was going to be a prosecutor. It's not a bedtime story, it's the truth. And I spoke with a number of them, and I asked, what's the toughest thing about being a prosecutor? And the number one answer was respecting a defendant's rights. One of the prosecutors profiled in the Harvard study I talked about earlier, Bob Macy, had over half of his death sentences overturned because of prosecutorial misconduct. Misconduct is not rare. That and a lot of other things tend to go wrong at trial, and I see it because I have a bird's eye view, and it's my job to review these cases for constitutional violations. It's just one example of a common rights violation. There are many instances of prosecutors suppressing evidence that would tend to show that the defendant is not guilty, because they have so much other evidence that points towards his guilt, and they feel so confident within themselves that he is guilty that they want to ignore anything that would go against that. But the defendant, is that the right slide? Yeah. The defendant is entitled to this evidence. The prosecution during its investigation is likely to turn up evidence that cuts against its case, and the courts know that. And the prosecution is constitutionally required to turn over this evidence so that the defendant can support his defense. He's entitled to show he might actually be innocent, because he might actually be innocent, no matter how firm the prosecutor's conviction that all the other evidence points to him, so it must be him. And the jury is entitled to hear this evidence because it's entitled to hear all of the evidence for and against conviction, because it has to make its best educated guess. Nobody knows for certain. The prosecutor wants to control the narrative, and the prosecutor wants to make the jury believe that the prosecutor knows, as if the prosecutor was there. And that's often what happens because the prosecution withholds crucial evidence. And that's the reality of the machine. So taking another of my cases as an example, this case was done. It was cold. The client was very close to being executed. His case was all about identity. It was a robbery of a drug house. 2 young men who were selling drugs out of the house were killed during the robbery. There were 2 young women in the house. They were left alive. They were taken from one room and placed in another during the killing, so they didn't see who actually pulled the trigger. But they saw the 4 robbers enter the house. So they got a look at everybody that was involved. Well, the police only caught 3 of them. So the girls say it was the short guy. The short guy was running the show. So the prosecutor's theory is the short guy was running the show. They heard the short guy saying to the young men who got killed, "Get down on the floor." The short guy is the shooter. The police catch 3 guys. 2 guys are 6'0" and higher. My guy is 5'9". My guy becomes the short guy. Years later, the case is cold. My job is to look over everything that happened. Part of that is to get records. I request records from the prosecutor's office. Now, when a case is old and over and done with, the prosecutor tends to forget what they gave and what they didn't give. So I got a lot of stuff, including stuff they didn't give. And I got police reports showing that initially, in their statements to police, the young lady said that the short guy who was running the show, who they heard saying, get down, was only 5'4". The 4th guy that was never caught was shorter than my client, and there's evidence pointing to the fact that he was around 5'4". The jury never got to hear that information, and my client became de facto the short guy because he was shorter than the other 2 that were caught. With this new information, we actually went and talked to some of the jurors from my client's case, and they were really upset. And they said, had we known this, we wouldn't have given him a death sentence, because This creates too much doubt in our mind that it could have been someone else, that it could have been the person that was 5'4". And that's one example from one case of one type of violation. There are many others, and they occur often. Another really big problem is ineffective counsel. The Sixth Amendment guarantees the right to a lawyer to assist you at trial, but what happens if that lawyer has no idea what they're doing, or worse, doesn't do anything at all and sleeps through your entire trial? That's a real case. It's not one of mine, thank God, but it's a real case. And the courts actually told that defendant, you cannot have relief because you cannot show for certain that your lawyer slept through the important parts of your trial. Withholding evidence is a big problem. Ineffective assistance is a big problem. And there are lots of other big problems, and we still put people to death despite these systemic failures. And of course, no one expects trial to be perfect or prosecutors to always play fair. And thankfully, defendants can appeal their convictions and raise these issues. But there's another problem, another mechanical failure in the machinery of death. Most appellate judges are elected. They're not immune to politics. Right out of law school, I clerked for a judge. Most people don't know this, but law clerks actually review the cases and the law and write the opinions. A lot of judges just rubber stamp and sign their names. Some judges are a little more involved, but my judge was a rubber stamp judge. However, on my first day of clerking, she brought me into her office, and just as casually as telling me what font she wanted me to use to write the opinions, she said, I'm elected and I'm a Republican. So, on civil cases, we can go either way, but in criminal cases, generally fined for the state. I was shocked. There was no attempt whatsoever to be impartial. There was no regard for the facts of any criminal case that came before her. Fined for the state. So when my 5'4" case lands in front of that judge, what's going to happen? That judge or any judge like her is going to tell her clerk, shut it down. If there's any way to shut it down, fined for the state. And there are plenty of ways to shut these things down. Just because I or someone else finds something very seriously wrong with a case, that doesn't mean that something will be done. Compared to state courts, federal courts, where I typically practice because I'm a federal capital habeas attorney, they can be serious watchdogs and protectors of constitutional rights. Learning about the landmark federal cases that helped defendants whose constitutional rights were violated get relief is what made me want to do this work. But federal judges, they're appointed forever, and they don't have the political pressures that elected state court judges do, but still their hands can be tied. And they can have strong political leanings based on who appointed them. So I have yet another case. Hopefully you're not getting tired of these. It's from a rural county. Well, first let me explain. The Supreme Court ruled recently that although what goes on in a jury room during deliberations is typically absolutely off limits, in cases where evidence that racism and racist remarks played a role in the deliberations. So let's say they convicted your client strictly because he was Hispanic, and jurors came forward and said, this is what happened in the jury room, and I was not okay with that. Typically, you're not allowed to use anything that happened in the jury room in court, but there is an exception for that. You can now use what those jurors said happened. So you can provide evidence from jurors of what happened to show that your client was unfairly convicted based on race discrimination. So we have a case that came out of a rural county in Ohio with a very well-known racially polarized climate. It has a huge Klan presence and a tiny minority population, of which my client was one. So we get the bright idea to investigate what happened in his jury room now that the law says we can. And we find exactly what we expected to find, and exactly what you probably can imagine we found. My client was African American. However, there's another Supreme Court case that prevents federal habeas petitioners from taking advantage of new rules announced by the Supreme Court unless they're specifically made retroactive. So we had arguments for the federal court for why we were an exception to this rule, and the court could have found in our favor. We had creative arguments, but the court didn't find in our favor. My client may go to his death because not that he's the worst of the worst, but that he had the worst jury ever. The machinery is broken. And with that, we come to clemency and execution. Clemency is an act of mercy or leniency, usually by a very politically entangled government official. In Ohio, it's the governor who would grant clemency or not. If you have evidence, like in my race case, that the courts cannot or will not hear, clemency is like your only hope. Also, if you have evidence that you're actually innocent, that it's too late to raise in court, the Supreme Court has said to look to clemency for relief. That's right. It's not unconstitutional for you, an actually innocent person, to be executed, as long as you were given an opportunity to receive mercy. I repeat, it is not unconstitutional for you, an actually innocent person, to be executed, as long as you were given an opportunity to receive mercy. The machine is broken. In closing, the state-sanctioned killing of a U.S. citizen, no matter how vile that person may be, should never be taken lightly. There's evidence everywhere that the system doesn't work in an impartial manner, and we aren't executing people based on the gravity of the offense they commit. We execute people because of politics and poor lawyering. We execute people in spite of case after case where prosecutors withhold critical evidence because they believe they have the right guy and they want death at all costs. I'm not often fighting for my clients' freedom. I'm simply fighting for their lives, because if their trial had been constitutionally tried, they wouldn't have received a death sentence, just as the juror said in my client's 5'4" case. There are many, many valid and compelling reasons to believe that the death penalty itself is morally repugnant and that we shouldn't have it for that reason alone, regardless of whether or not it is constitutional. But even if you're unwilling to accept that proposition, it is absolutely cruel to ignore the fact that our current system for administering the death penalty is so flawed and so broken that it is unconstitutional and cannot go on until it is fixed. So I hope you go forward, ask more questions, ask if we're okay with this, and ask if there is indeed any possible way to fix it. And with that, I will thank you for listening and ask if you have any questions for me. Yes.
Not any kind of lawyer at all, but is there a legal difference, or what can you say about the difference between revenge and justice, in the sense that I can sit here and think all of it's revenge pretty easily?
Well, there's a fine line. So the underpinning for the death penalty is retribution, and there's a fine line between retribution and revenge. So retribution is basically revenge prettied up. We call it justice because we try to carry it out through this process. We stack the Constitution on top of it and we say, we give you all these protections, we treat you like a human being, we give you the benefit of the doubt right up until the end. And for that reason, we're not animals chasing you down in the street with pitchforks and treating you like a dog. So it's not revenge, it's justice, if that makes sense.
Well, just, is there something a little more legal? So for example, someone steals my bicycle and goes to jail. It doesn't exactly seem like, you know, like I can define justice in my head a bunch of ways more equitably than someone going to jail. Is that revenge? You know what I mean? I'm just curious, is there really a legal, anything that's been teased out legally, what's the difference between justice and revenge? Or is it more like a common sense, social, political question?
Oh no, it's more of a sort of like a philosophical, like the legal underpinnings are like going back to Kant and lex talionis, and you know, if you look in Black's Law Dictionary, you're going to get lex talionis and retribution. An eye for an eye. That's the underpinning that's going to pop up.
Okay, it's just because if someone assaults me, it's not, I just want to push this just a little further. I don't get to hit them back. We don't, you know what I mean? Mm-hmm. Where's the definition for that? Why is that?
Because, well, what do you mean? I'm not sure I'm understanding your question now.
If the idea that if somebody kills someone, they're eligible for the death penalty, if we're trying to see the difference between justice or revenge in that case, this is where I just, not any kind of lawyer, it would seem that if somebody punches me, they go to jail. We call that justice,
right,
versus me being able to punch them in the face. And the whole eye for an eye, tooth for a tooth would be why. So it sounds like the death penalty is the only one where you actually get an equivalent retribution, right? Everything else is different.
Right, but it's state sanctioned, which is supposed to elevate it from pure revenge. And so the death penalty, and that's one of the things that makes it so controversial. It's one of the only ones where it's sort of the government trying to do the eye for an eye thing, but trying to do it trying to put it in legal clothing. Oh, yeah.
Okay. I have a question about the jury. You mentioned that they should be free from external influence, but don't you want them to have external influence because they have a background in the case? Does that make sense? Like, you want a well-informed citizen to be a juror?
No. You want an absolutely ignorant citizen. Absolutely ignorant. They search for okay, so before you start a trial, you have a process called voir dire. You bring in a whole lot of people, more than the 12 that you're going to choose at the end, and you ask them all questions. And one of the questions that you're going to ask them is, do you know anything about this case? Do you know anything about anything that has to do with this case? And if they know stuff, you want to drill down and see how much they know. You want them to know the least possible. And sometimes if they know anything at all, you want to get rid of them. Because any judgment that the juror is going to make, you want to come solely from the evidence and the testimony that's presented in the courtroom. That is supposed to be the clean slate and the sole basis of any judgment that the jury makes about whether or not your client's innocent or guilty. Her hand went up first.
I was just wondering, the next time in Parliament, are we able as a society to have no external forces when it comes to us? Like walking down the street or any kind of thing, we usually have some sort of force driving us in our own identity. So isn't it kind of counterproductive to say we don't want external forces when we've all been had us throughout our life? Does that make any sense?
That makes perfect sense, and that's the conundrum of the death penalty, and one of the reasons why we probably shouldn't have it. I mean, I pose the question, come up with a way to have it that deals with all of those issues. People do impossible things every day, so if there's a way to figure out how to remove that bias and those factors, then go for it. I'm saying that if there's a way to come up with a process that deals with all of the issues that I talked about today, then the death penalty, at least, you know, as Justice Blackmun, how he felt, and how to a certain extent I feel, wouldn't necessarily be wrong. But the process that we're trying to do, because we are so flawed as human beings, we cannot carry it out for the reason that you're talking about. We can't remove our own biases and our own experiences. We're looking through this lens and we're trying to judge another human being. And that's a component that I didn't even speak about. You literally actually have to weigh the other person's life. Evidence about their entire life history comes in. It'll be things like he saved a man from drowning once, he served in the military, things that have nothing to do with the crime, and you're supposed to decide, does this person seem like, even if they committed this crime, they're good enough to live? And there's just something icky about that.
Yes. Now, I'm completely ignorant about legal matters, but the question is, if a prosecutor is withholding information, is there no mechanism at all for the defense to be able to get that information in the system? Is that completely absent, a way for the defense to be getting that information?
Right. So typically you file a motion with the court that says we want the prosecution to turn over everything that they have, and then the court compels the prosecution to turn over everything they have. The prosecution simply doesn't turn over everything they have. They just don't. And then you don't find out until years and years later when somebody new is in the office and they don't realize that, they turn over stuff that they didn't realize they hadn't turned over before. Yeah. Sure, it's extremely frustrating, but there are extreme legal gymnastics going on. With the most recent issue with the lethal injection being allowed to go forward because of the court ruling, part of that is the extremely conservative court that we have now. I mean, again, politics is seeping into this. And what they did was they said, the Eighth Amendment prohibition against cruel and unusual punishment has to be cruel and unusual in comparison to something. So you can't just say, and this blows my mind, but this is their logic, their new logic that they found somewhere in the Constitution. You can't just say, it's unconstitutionally cruel to flay me alive. You have to say, it's unconstitutionally cruel to flay me alive because you have a different way to kill me that's less painful. If the state doesn't have a different way to kill you that's less painful, they're not being cruel. They're just flaying you alive. I mean, it's not like they could have something less painful they could be doing to you. Like, that's what the court basically said. That's their reasoning, in a nutshell, in a very non-legal nutshell. But that's the breakdown of what they said. And as far as Herrera is concerned, they said, look, things have to come to an end. And if you want to say that you're innocent at a late stage in your case, when it's already been reviewed several times, and you've been found to, your sentence has been found to be constitutional, and we're ready to kill you, and you want to come out of left field saying you're innocent, even if you have, and Herrera did have some compelling innocence. He had affidavits, and he had several people saying this person was the actual killer and this person confessed and that sort of thing. Don't bring that to us, because we don't want you to perpetuate the court process over and over and over. It has to end at some point. That was their logic. And so they said, as long as there is some other process available to you for you to have your innocence recognized and validated, then it's not unconstitutional to execute you. You had your opportunity to have your innocence validated. And they included clemency within those processes that would qualify as good enough. So as long as clemency is available to you and you present your innocence information to that, they can go ahead and kill you. Yes.
So just coincidentally, I was at a talk last night where there was a federal district court judge, a Ohio State Supreme Court justice, and a county municipal court judge. And they were talking about the topic of wrongful conviction, but they were also kind of touched on the death penalty. And one of the things that I sort of hadn't known, and I wanted to ask you about it, is they said that the likelihood that you will be given a death sentence in a county like Cuyahoga County is much higher than in rural county because it takes $1 million. And so in a rural county or a smaller county, they can't actually afford the litigation that's associated with the death penalty case. So they never even try. So it's not just, they were making the argument that it's not just the prosecutors. Like the prosecutor may actually want to seek the death penalty, but they can't because it would basically go beyond their budget. Have you come across that? Or?
Oh yeah, I have a case that actually made like national headlines a while ago because I'm not going to go into everything that was going on in that case, but basically they really wanted to try it as a death case, but it was a really small county and they didn't have the money. And the judge actually told the prosecutor, look, we don't have the money, we cannot charge this as a death case. So the judge overruled what the prosecutor wanted to do. And then the AG stepped in and said, we'll pay for it, we'll fund it. And it ended up being charged as a death case. So that absolutely happens.
So what's your theory on like why some people have such a strong death drive for other people? Because it's, you know, getting back to what Mary's question was, like, yeah, I mean, we can recognize that if one individual like flays another, that's not cool, right? But somehow if we have these processes in the back that make it look like it's cool and it's justice, it's okay. So what is driving the desire, just in your opinion, really, to kill people, even when they're innocent? You know, what, you know, I don't know. I find it such an odd thing, and you must have thought about it at some point.
Well, I think it's a controlled narrative. I think there's always sort of, we have these innocence cases that come out, and it's like, look, you almost killed this person and he was innocent. But there's always going to be someone out there who believes that just because he was charged and convicted in the first place, his innocence, there's always a shadow of doubt over his innocence. And so they're always going to place more faith in the system than they do in any evidence that he was never wrongfully convicted to begin with. I think that there are just people who have sort of blind faith in the system, the justice system, and the narrative that is the controlling narrative, and the narrative that society consists of monsters that need to be eradicated, and they don't understand that, like with case A and case B, there's not a consistent, you know, we're just throwing darts out there at who's a monster and who's not a monster. And I think that there's a narrative that's being driven that society at large doesn't recognize what's actually happening behind the curtain. So they feel that the monsters deserve to be executed, and we need to continue this process to cleanse society of the worst, lest to be overrun by them, if that makes sense.
I mean, do you think after at least after the sentencing stage, it also becomes an issue of these people are implicated in the system, right? And if you recognize innocence or some other kind of error later on, then they're implicated in that error. And they don't want to implicate, you know, prosecutors, for example, right? Like, why they'll insist to the bitter end that they were right. Because then they have to admit that the system in which they are a part, in which they are upholding, is deeply flawed, and that calls into question their own legitimacy in a certain kind of way. I mean, do you think that's part of it as well?
Oh, absolutely.
Or generally, can you have a trial by a jury of your peers in a systematically racist society? Is that possible? or systematically classist society? Or, I mean, people don't see themselves necessarily as people's peers.
That's a really good question, because there's a big gap as far as who's being charged and who's being brought to trial, and it's an income gap, not just a race gap. And so when the person that's sitting at the defense table is someone who is from a very impoverished background, the jurors aren't going to be from that same background, so they're not necessarily going to be peers in that sense. As far as sort of cross-racial issues, we still have issues of getting things like all-white juries, and in some place like Cuyahoga County, which is a very diverse county, and things like that. I think that with the issues that we have in the nation that aren't really going anywhere anytime soon, I don't think, it's not really realistic to think you're going to get peers.
But it's also not a constitutional guarantee, right? It says impartial jury, the Sixth Amendment doesn't say jury of your peers.
Well, you're supposed to get a fair cross-section, so.
I guess I always understood the court to say, right, basically, that's why we allow strikes, right? Because we know that you're not going to get a good cross-section, and you should actually be able, each side should be able to shape the jury in the way that they feel is going to benefit them. And it's, or maybe
Well, actually, there's a lot of, so Mississippi actually for a little while got rid of the striking system for that reason, because it was being abused and it was getting in the way of the fair cross-section guarantee. So there's a lot of tension between having that in place and the fair cross-section guarantee, and the strike system is not a constitutional concept. That's just something that is done. So the fact that that's allowed, I don't think should interact with the constitutional guarantee in the way that you see it interacting.
Okay, because maybe I'm misconstruing it, but it says impartial jury, and the jury of the peers is just sort of something like, you know, wall of separation between church and state, which just kind of come into the atmosphere, but not really a part of the Constitution. So I guess I'm thinking about the language in the Sixth Amendment, which simply says that you're guaranteed an impartial jury versus a jury of your peers.
Okay, I'm thinking of the law that has been built on top of that since then, and how that has shaped what the Sixth Amendment says. So the law interpreting the Sixth Amendment would then go to, no, you're entitled to much more than that. You're entitled to a jury of your peers. You're entitled to a fair cross-section. You're entitled to not have women or minorities or this or that excluded. So that would be a constitutional requirement.
Right. I mean, I guess you can't strike on race, you can't strike on gender. How do they actually put into practice a guarantee of a cross-section? Just building on what Liz is saying, like, that's not, it's, how are we gonna, how does that actually?
To increase the sample size.
Right. Well, I mean, you can start, right?
Yeah, people have done like statistical studies and said, look, like there was a case where all of the jurors were from the same street. And they were like, that's not a fair cross-section. You know, like things like that. Or, so they'll take you should have gotten jurors from these locations, you should have gotten, you know, this sample population in the veneer, and you didn't. So that's sort of how a fair cross-section claim starts out.
Got it.
So do you have to, I mean, so are they basically kind of saying, like, are they saying fill certain quotas, like you can't, like, or select who you select and then think of why you, like if they all have to live on the same street and start over, like how do they do it?
Well, usually you'll catch the fact that they all lived on the same street, like way after everything is over with. So then you're trying to say we need a new trial, and at that point it's good luck. So that's what I do. Good luck.
Well, unless, are there any more questions? Thank you so much.